Good morning, everybody. As part of our mission to discuss the entire Constitution, highlighting wherever it was misused, misunderstood, and misapplied, as a result of which the country is experiencing social, political, economic, and law and order problems for the last 75 years. We have completed our discussions up to Article 238. Today, let us discuss one article, 239, relating to union territories. Union territories are not equivalent to states. States are administered by the governors of that state. Governor is the executive power of the state, which extends to all the matters on which the state is entitled to make law. Whereas union territories are administered by an administrator to be appointed by the president under Article 239. The governor, being executive power of the state under Article 154, is required to act in accordance with the Constitution with aid and advice of the Council of Ministers under Article 163 and 164. Wherever there is ambiguity, the governor shall consult the president under Article 161 and shall act accordingly. Whereas the administrator of a union territory is not a governor and he is not given the authority to be executive power of a union territory. Executive power of union territory is vested in the President of India in terms of Article 73, which reads that the executive power vested in the President of India shall extend to the whole of the country, including states and union territories, in matters which the union is entitled to make law. As such, President is the executive power of a union territory. It is further held that the President may appoint any neighboring governor to act as administrator of a union territory. In such case, the governor is not bound by advice of the Council of Ministers. He shall act independently. There are similarities between the powers of the administrator and the governor, but of course the administrator, by whatever name called, is not the governor. A governor under Article 163, it contains that there shall be Council of Ministers with Chief Minister as head to aid and advise the governor in exercising his functions. However, the minister shall not be entitled to advise the governor in matters which require his own discretion. In 154, when it was said that the governor shall be executive power of the state, it also said that he shall execute the same either by himself directly or through officers subordinate to him. It means that he can execute his functions directly also. In consonance with that, it is said in 163 that minister shall not be entitled to advise the governor in matters which require his own discretion. Article 166 also is in tune, is in similar line with Article 163. It states that the governor allocates departments to the ministers. While allocating such functions, the governor shall not allocate such functions to the ministers which require to be executed in his own authority, in his discretion. That means ministers are a low-level people. They are subordinate to the governor. Article 164 says that they are appointed by the governor and they are removed at the pleasure of the governor. These are not elected people, appointed people for the purpose of aiding and advising the executive. So today we will conclude with this small video of the status of union territories under Article 239. Delhi was also a union territory until 1991. We will discuss in detail about Delhi status. Delhi cannot be a full-fledged state. It is a union territory. It should continue to be union territory only. Even if there is an elected chief minister, there are provisions. He has to act according to instructions of the president. That we will discuss in detail in our next coming video. Thank you. Thank you for watching this video. I request you to please subscribe, share and comment on my videos. I will be glad to reply to your worthy comments.